You want to know how desperate Donald Trump is right now? He is citing Special Counsel Jack Smith as authority before the Second Circuit Court of Appeals to ask for emergency relief to try to stay or pause the E Jean Carroll defamation case from going to trial in January. You heard me correctly. Donald Trump is citing Special Counsel Jack Smith, where Special Counsel Jack Smith talks about the importance of absolute presidential immunity. And Donald Trump is saying that, look, Special Counsel Jack Smith thinks absolute presidential immunity is so important. Look what he's arguing to the United States Supreme Court and the D.C. Circuit Court of Appeals. Second Circuit, I need your help. Listen to what Jack Smith is saying. Okay, let me break all of this down for you right now. So, in January, the second defamation case brought by E Jean Carroll against Donald Trump is set for trial. You'll recall back in May, E Jean Carroll prevailed against Donald Trump in her sexual abuse lawsuit and defamation claim and was awarded $5 million. Now, recently, Rudy Giuliani was hit with a $148 million verdict against him last week. E Jean Carroll has the same expert that Ruby Freeman and Shay Moss used in the defamation case against Giuliani. And now that Donald Trump has previously been found to be liable by a jury in the first E Jean Carroll defamation and sexual abuse case, and because Donald Trump has continued to defame E Jean Carroll, this next trial in January, based on Donald Trump's defamatory statements made while he was in office or disgraced the White House in 2019, and the punitive damages, which will also be based on the continuing statements he's been saying. The jury will get to hear that. It's going to be a Giuliani-style wipeout, and Rudy Giuliani just declared bankruptcy. So Donald Trump sees that date approaching in January. Now, Donald Trump's lawyers made a very big error in the E Jean Carroll defamation case. Because Donald Trump's statements, defamatory statements against E Jean Carroll for this next defamation trial, this next defamation case, were made while Donald Trump was in office, ostensibly he could have asserted an absolute presidential immunity defense, an affirmative defense. Do you know how you plead an affirmative defense? In your answer to the allegations against you, or in an amended answer that you should file timely, all you have to say is this: for Donald Trump's first or second or fifth affirmative defense, he hereby asserts absolute presidential immunity. He could have at least preserved the defense had he done that. But for 3 years, let me repeat that, 3 years, his lawyers did not assert absolute presidential immunity as an affirmative defense. And then they tried to basically do it for the first time in the past few months. And the federal judge, Judge Kaplan in New York, who's been presiding over these federal defamation civil cases against Donald Trump, said, too late. You've waived it. You've waived it. So then Donald Trump appealed to the Second Circuit Court of Appeals, which is the boss of the New York federal courts, among other courts. And the Second Circuit said, you waived it. You had 3 years to assert absolute presidential immunity, and you failed to assert it. And on that grounds, you don't have absolute presidential immunity. That was something that his lawyers could have easily done. As I told you, it's one sentence that they failed to do. A very costly error. I mean, there's actually a potential that Donald Trump could have argued, just like the Nixon v. Fitzgerald case, where Richard Nixon was found to have absolute presidential immunity in a civil case involving the wrongful retaliatory termination of Fitzgerald. Trump's arguments plausibly could have argued. I think they would have still lost it, but I want to be objective as a reporter here and say they could have at least argued, look, Donald Trump's defamatory statements in 2019, unlike the ones he made in 2022 against E Jean Carroll, occurred while he was in office, during press conferences, during interviews. These are the types of things in the outer perimeter of what presidents do, even though the conduct itself may be abhorrent and deplorable, so therefore absolute presidential civil immunity should apply. This is different than, say, the Blassingame case, where the D.C. Circuit Court of Appeals recently held that Donald Trump's conduct relating to the January 6th insurrection fell outside the outer perimeter established by the Nixon v. Fitzgerald early 1980s case, because in Blassingame, Trump's conduct relating to the January 6th insurrection did not involve Article II executive powers. It involved campaigning and election activity, which is not within the outer perimeter of what presidents do. It's not like hiring and firing like the Fitzgerald case. Just by the way, if you're a little bit confused about the doctrine, there is absolute presidential immunity in civil cases. What Judge Tanya Chutkan, the federal judge presiding over the Washington, D.C. federal criminal case against Donald Trump, ultimately decided, and this seems to make sense based on the text, structure, and history of the Constitution, is that no, former presidents do not have absolute presidential immunity in criminal cases. So Donald Trump is appealing what Judge Tanya Chutkan ruled in the D.C. federal criminal case. He appealed to the D.C. Circuit Court of Appeals, the boss for Washington, D.C. Federal judges. Special Counsel Jack Smith sought and was granted expedited briefing before the D.C. Circuit Court of Appeals on the issue of absolute presidential immunity, since Judge Tanya Chutkan denied Donald Trump's motion to dismiss the indictment on absolute immunity grounds, finding that former presidents do not have the right to claim absolute presidential immunity. And then Special Counsel Jack Smith went directly to the Supreme Court and said the issue of absolute presidential immunity is such an extraordinary issue, the United States Supreme Court needs to hear this issue of absolute presidential immunity right now. So again, just to frame this for you in clear terms, where we are with the law is that Nixon v. Fitzgerald says the outer perimeter of absolute presidential immunity in civil cases. It recognizes absolute presidential immunity in civil cases. Blassingame says Trump's conduct fell outside the outer perimeter. But in criminal cases, Judge Tanya Chutkan said former presidents are not entitled to assert that doctrine of absolute presidential immunity. So what is Donald Trump now doing in the Second Circuit Court of Appeals? Why is he citing Special Counsel Jack Smith? At the same time, Donald Trump is just argued to the United States Supreme Court when Special Counsel Jack Smith's trying to get a direct appeal to the United States Supreme Court saying these are extraordinary issues. Donald Trump's arguing to the United States Supreme Court in the criminal case, in the criminal context, no, it's not. Supreme Court, let's halt this process. Slow down here. Let the D.C. Circuit Court of Appeals go first. Let them decide. Donald Trump said in his brief to the United States Supreme Court, where Jack Smith is seeking a direct appeal on the issue of absolute presidential immunity in the criminal case based on Judge Tanya Chutkan's ruling, Trump is saying, haste makes waste, Supreme Court. Do not rule on this now. Delay, delay, delay. So that's what he's saying there. But here's what he's doing with the Second Circuit Court of Appeals. He's saying, look, Second Circuit Court of Appeals, you may have ruled against me and found that me and my lawyers waived absolute presidential immunity in the civil case involving E Jean Carroll because we didn't assert it as an affirmative defense. You may be saying that, but Donald Trump says we shouldn't go through the trial in January in E Jean Carroll. We shouldn't have that trial because he goes, I want to go to the Supreme Court, and I'm contemplating a petition for certiorari, oral argument before the Supreme Court, on the issue of absolute presidential immunity in this case. And then Donald Trump says, look, Jack Smith says it's important. Jack Smith says it's extraordinary. What Donald Trump really doesn't address, though, is when Jack Smith's saying it's extraordinary so the criminal case can be heard immediately by the Supreme Court, you're telling the Supreme Court, no, delay. This isn't something that you should be hearing now. But then at the same time, you're now telling the Second Circuit Court of Appeals, hey, Second Circuit Court of Appeals, look what Jack Smith's saying. He's saying that absolute presidential immunity is such an important issue. That is why, Second Circuit, Do me a solid here, Second Circuit. Donald Trump is saying, look, Second Circuit, halt this E. Jean Carroll case in January. Stop it from happening, because I want the Supreme Court to rule on this first. In other words, Donald Trump is making contradictory arguments to the Second Circuit and to the Supreme Court, but with the same goal, because he's got one move: delay, delay, delay. So what he's hoping that the Second Circuit Court of Appeals does is that they stay the mandate, that they stay their direction to the district court in New York to proceed with trial in January. And Trump wants to use Jack Smith's arguments to the Second Circuit to stop the E. Jean Carroll trial, because Trump's terrified. He knows he's going to be wiped out. But here's the thing. Here's the distinction. Donald Trump asserted absolute presidential immunity by way of a dispositive motion, a motion to dismiss the indictment in the federal criminal case. He asserted it, and therefore there is no dispute that he waived it. He didn't waive it. I mean, he doesn't. We all believe in the legal community, who seriously study the Constitution, as Judge Chutkan did, that the history, text, and structure of the Constitution is such that Donald Trump is not entitled to it, but he at least asserted it timely. But in New York, he never asserted it for 3 years in the federal civil case brought by E. Jean Carroll. And that's where the Second Circuit said, dude, you waived it. Your lawyers waived it for you. You don't have it. But now Trump's saying, please, 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 look, Jack Smith says it's important. I may want to argue this to the Supreme Court. Even though I'm arguing to the Supreme Court right now that they shouldn't hear it, I may want to argue that they should hear it as it relates to E. Jean Carroll. Folks, here's what E. Jean Carroll's lawyer, Roberta Kaplan, is going to say. This is a bunch of nonsense. That Donald Trump is arguing in the Jack Smith case for the Supreme Court not to hear it. The Jack Smith case involves a different set of issues. It's not a civil case. It's a criminal case, and it involves a former president trying to assert it in a criminal case to derail the trial from taking place. It involves a criminal case. And here, this is a civil case where Donald Trump didn't assert it. So there's no reason why this is even a case that should go before the Supreme Court. He waived it. He lost his right. Let's go through with our trial in January. And one of the things that Roberta Kaplan, E. Jean Carroll's lawyer, is also going to say too is that E. Jean Carroll is getting older. She needs her day in court. Donald Trump is trying to kind of torture her again with these twisted litigation tactics, and do not countenance his behavior here. These are just pure, unadulterated delay tactics by Donald Trump. But you see what Donald Trump's doing? On the one hand, Supreme Court, you shouldn't hear Special Counsel Jack Smith's direct appeal. These issues are not that extraordinary. Let's go through the normal process. Chill out, Supreme Court. Why he wants to delay the criminal case. E. Jean Carroll, he's arguing, whoa, this is extraordinary. We need you to do emergency relief. I mean, by the way, here's the brief that Donald Trump filed. It's called a memorandum in support of emergent motion for stay of mandate and stay of the district court proceeding. I think he meant not emergent motion. I think he meant emergency motion. But here's Trump's memorandum in support of emergent motion. And what's he's asking for? He's saying stop the E. Jean Carroll federal trial from taking place while he contemplates whether or not to seek certiorari from the Supreme Court based on the arguments Jack Smith is making. Total BS. He's terrified, though. He's terrified right now. These moves show fear. They show terror. They also show incompetence. And with good lawyers like Special Counsel Jack Smith and Roberta Kaplan for E. Jean Carroll, they're going to point all of this out. And again, Trump is twisting himself into knots right here and looking like a very fearful person. You can see the fear seep through these lines right here. But we'll keep you updated. We'll see what Donald Trump's doing. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. Thanks to your support. Have a great day.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.